We now move to the Middle Ages and the early modern period. The first speaker is Professor Albrecht Cordes. He is a chair of medieval and early modern legal history and civil law at Goethe University, Frankfurt am Main.
Genau.
Not an order.
Nicht an der Oder.
Nicht. Since 1999, he published a book on the constitution of small towns and villages in the Upper Rhine Valley, 15th and 16th century. Second book, how Asiatic company law, a little earlier, the 13th and 14th centuries. His researches focus on legal history of the Hanseatic League and pro-modern commercial law. He will speak on medieval forum shopping, the demands of Hanseatic merchants in regard to civil procedure. Please.
Thank you. How do I start the PowerPoint?
You don't know where?
Is it on the computer?
Yes.
First thing to do, I guess, is to open up this.
I'll do it.
Ah, here it is.
It should be this.
It says Berg shortcut, that's the one.
כן, זה יעזור. הפרוז'קטור לא דולק.
Oh, we delay.
הוא דולק?
It's coming.
Yes.
Yeah.
25 minutes.
There you go. It's on.
Including the warming up of the projector.
No, not included.
Thank you. And is this now click it? Thank you.
If you want to move a little.
Oh, okay. Thank you. Okay. Thank you for inviting us. Like this? Okay. Thank you for inviting us, and please forgive me for changing my subject. I think the original planned subject on maritime law would have been interesting for the question of a universal juridical order, but when I took a closer look at it, the assumption that this is the fact became more and more dubious to me, so I changed back to something where I felt more secure, and the maritime things will need more consideration before I can go in any way publish with that. So instead, I focus on one special point of overlapping jurisdiction, and that is the competition between the which necessarily must emerge when jurisdictions overlap. And I do that with a very special example, so maybe I am too specialized, but I think the focus on the competition between those overlapping juridical systems is important. This is always, overlapping jurisdiction are and always were a challenge for any community, but were nonetheless normality in the Middle Ages. Imagining a marketplace in a medieval city, let us say at the Frankfurt Book Fair in the late 15th century, and the courts having jurisdiction over its visitors. Foreign merchants, monks, students, ordinary citizens, prostitutes, beggars, vagabonds, perhaps some imperial soldiers, visiting farmers, stonemasons from the construction site of St. Bartholomew's Church, the so-called Kaiserdom, Jews, harbor workers, shipmen busy with the river trade, noblemen from within and outside the city. All of these groups would potentially had to answer to different courts, and many of them not only to a single court. One of the said noblemen, for example, could have turned to a feudal court, Lehensgericht, in matters regarding his fiefdom, the town council acting as fair court in regards to a letter of change due to him at the Easter Fair, and to an ecclesiastical court because he wanted to marry his cousin and needed a dispensation from the interdiction against marrying relatives. And for quite a few such cases, there would have been more than one court claiming jurisdiction. Basically, that's what we said in the discussion, that the lazy students would come up with 100 different legal orders in which they are involved within 24 hours. Giving the colorful, albeit confusing panorama, the perspective that we may now, at our conference poster suggests, actually return into a world of overlapping jurisdictions. So that's the past pluralism and the future pluralism we heard about already. This does not frighten medievalists. In the early modern period, in spite of all sovereignty claims of kings and princes, things did not change fundamentally. Even on an imperial level, there was no clear delimitation between the two highest courts, the imperial chamber court in Speyer, later in Wetzlar, and the imperial Aulic Council in Vienna. Their jurisdictions overlapped nearly completely, and only very few matters, for example, ennoblement, were exclusively dealt with in Vienna. Apart from that, the court which was involved first would hear the case, and neither court would accept a claim when the other one was already working on it. But you don't have to take my word for it. Antonio Manuel España, the leading Portuguese legal historian, puts it like this, quote, "The situation of legal pluralism or mixed jurisdictions was normal in the context of early modern political and juridical imagery. Several powers, several political statuses, several laws, shared social space, none of them pretending the exclusive social regulation," unquote. And even in the heyday of the nation-state, the period of supposedly stringent national rule and centralized jurisdiction, there were more than enough areas the state justice would delegate to more or less private players like chambers of commerce and the like, a subject Peter Collin has taught us about quite a lot. If jurisdictions overlap, they necessarily start competing with one another. They can try to impose themselves with sticks or with carrots. In the Middle Ages, the common way of fighting for one's own jurisdiction was threatening the members of the own community with severe fines if they took their conflict to outside instances. For example, citizens suing their enemies in front of anybody else but their own town court, or threatening any third party to sue one of their own. The adamant claim of the canon law courts of exclusive jurisdiction over all clerics is the most important example for this. So far for the sticks. In this paper, I'm more interested in the carrots. In order to improve status and reputation of a given court, the interested parties could also try to make it more attractive. I want to ask what it took to make a medieval court attractive to litigants who had the choice between more than one institutions. One could perhaps speak of medieval forum shopping. And as with today's forum shopping, this is a question mainly relevant in the area of commerce and commercial law. This is why the merchants and their interest in civil procedure present a very fruitful case study. Oops. I want to look at the question through the glasses of the customers of the court, the Justiznutzer, as German sociologists and historians like to call them. In my sources, these customers are quite explicit in regard to their expectations. They gained trade privileges from the princes of the foreign harbors where they established their trade posts, namely the rich and famous Hanseatic Kontore in London, Bruges, Berg, Norway, and Novgorod. These agreements, although issued in the form of gracefully granted privileges, were in essence hard-bargained contracts. I want to focus mainly on two of such privileges, one exclusively for Hanse merchants present in Flanders in the middle of the 13th century, and the other for all foreign groups of merchants in London 50 years later, the well-known Carta Mercatorum by King Edward I. It turns out that more than half of the articles in these privileges regard civil procedure. This shows that there was no subject with a higher priority for the foreign merchants than the rules of litigation. Hence, the choice of my picture. The Hamburg Town Law from 1497 is divided into 12 chapters, and each chapter starts with one of these pictures, highlighting some of the subjects that then feature in the chapter. This is the opening picture for the last chapter, the one on maritime and ship law. In the lower right corner, we see 3 judges in an open-door courthouse, right next to the harbor, sitting on a table with green cloth, and the advice-seeking public is queuing all the way out to the street. In this paper, I want to take a closer look at the procedure courts like this should embrace according to the wishes and demands of foreign merchants doing business in this harbor. The most important issues were speed, effectivity in concerning execution, rational law of proof, abolishing of duels and other ordeals, and equal manning of the jury with fellow citizens from both parties. If one compares privileges from Flanders and England with those from other regions, 2 results become clear. A, the Hanseatic League did not try to impose a uniform set of rules upon its trade partners, but rather reacted in a flexible manner to the local circumstances. And B, it fought for these privileges with tooth and nail and used the strongest weapons at their disposal against any deterioration of their status. So I'm looking through I'm grouping the demands of these merchants into 6 subcategories, one being opening of access to the courts and remedy for foreigners. First and foremost, the merchants were guaranteed legal remedy in general, fare justitiam. The Norwegian justices were even held not only to provide the people of Lübeck with unobstructed justice, but even to treat their disputes with loving priority, quadam amoris prerogative. The access to justice is facilitated if the commercial court is situated right next to the harbor. So the position of the access, the position close to the place where the business actually pursued is of importance. At Bruges, the courts were not only in the city itself, but also in the harbor town of Damme, a few kilometers downstream and closer to the North Sea. The most famous visual display of such a harbor court originates from the illustrated manuscript I just showed you. It has been used so often in such different contexts that it has become a cipher for medieval Hanseatic seafaring in itself. The various types of ships in the upper half of the picture, just as much as the loading crane, in the lower left corner and the mentioned court. Crane and court are communal institutions to facilitate trade and, in the word of the new institutional economics, reduce transaction costs. By the way, there is a huge discussion about the ship types going on, if they are actually some of the famous Hanseatic cogs or not. That is one of the hottest debates in Hanseatic history right now, but I don't have anything to contribute to it, just citing others. Second point is preliminary remedy and securities. Preliminary remedies play a key role for medieval procedure. In an environment in which unwilling parties can easily escape the court's grasp, the result of the preliminary remedy procedure frequently is the factual resolution of the entire legal dispute. In cross-border medieval trade, this is even more important, as goods were often enough accompanied by the owner. If the foreign merchant was the plaintiff because of pursuing contract debts or because he had suffered damage, it was his decision whether he would prosecute his rights locally or if he was better off if he let the matter rest and continued his trading trip. However, if the foreigner was the defendant, the clash of interest is obvious. The suitor who was fighting for the enforcement of his title on the one hand, and the defendant who was interested in a swift resumption of his trip on the other. Were the sued merchants in danger to be fettered or even imprisoned? In Flanders, the defendant could avoid the loss of personal freedom if he had bailsmen or in rem securities, as long as he was not charged with a serious crime. The Norwegian clause is so similar that it may have been inspired by the negotiation in Bruges. A detailed regulation regarding when and how an accused merchant could be fettered can be found in an early Danish privilege as well. In Novgorod, it was agreed that neither a German in Russia nor vice versa a Russian in Germany could be imprisoned at all. In Flanders and Norway, the question whether a ship ready for departure could be confiscated by the creditor of its owner was discussed in detail. This shows how important the preliminary solution of the conflict was for the merchants and how thoroughly the givers of privileges weighed the conditions under which they were willing to let the foreigner escape their territory. General jurisdiction or specific trade law courts. Already in 1157, the English king guaranteed to treat guests from Cologne, their guests and goods, the same way he would treat his own people. Later, Hanseatic merchants from other cities referred to the same privileges. In case of infringement, satisfaction was promised. Plenariam justitiam faciatis. In the event of a merchant being sentenced to death and executed on his way to a trading destination or on his way home, in die non legitimo, in a non-regular court session, a fine was due to his heirs and relatives. At least in criminal law, the guests were treated legally in the same way as Englishmen. The model of the general court's competence for the disputes of Hanseatic merchants was implanted in Flanders as well as elsewhere. Another strategy was the establishment of special trade law jurisdiction. This was the case in England and France. Here, the merchants' disputes were unhinged from the competence of the general courts. Public officers who were already acquainted with seafaring, like the admiral and vice admiral of France, along with the bailiffs, seneschals, and governors of the most important harbors, were appointed to establish this jurisdiction by the French crown. Applying law. The privileges could also cover the question of which substantive law should be used in court. Again, we find the sources from England and Flanders to be the most informative. The English privilege from 1157 states that merchants shall have permanent peace to create their just custom. Firmam pacem habeant faciendo rectas consuetudines suas. Moreover, judges are directed not to demand new customers or charges, novas consuetudines vel rectitudines, from the merchants. In a Danish privilege from 1370, after a military defeat to the Hanseatics, the Hanseatic merchant used the weakness of their opponent by forcing them to assume the merchant's independence from Danish law. Also, they made sure that they could only be sued in front of their German reeve and according to the law of their hometown. Still, these two examples are the only ones which acknowledge foreign law in front of the courts of the Hanseatic merchants' hosts. Everywhere else, the trade law was part of the local law, of the national law of England, Flanders, or Norway. This is especially valid for the only textual evidence for a lex mercatoria in any of the privileges. In 1303, King Edward declared that conflicts about contracts with merchants were to be decided according to the customs of that market where the contract was agreed on, secundum usus et consuetudines feriarum et villarum, ubi dictum contractum fieri contigerit. Additionally, the bailiffs of the respective market were to decide the matters overnight and secundum legem mercatoriam. In turn, the privileges of Flanders are especially rich. After abolishing the hated custom of holding merchants responsible for their compatriots' debts, The Countess of Flanders declares that whoever is responsible shall atone for his own deeds alone and be punished according to the jury's verdict and the law of the land, which is Flanders. Law of evidence, witnesses, and compurgators. In the High Middle Ages, before around 1100, the parties had to pick their assistants from within the attendant court canton. Foreign parties were in an unfavorable position which resembles a game of soccer in which not only the spectators but also the referees are in the home team's favor. The Hanseatic merchants tried to evade this threat through the privileges. They insisted on the forums being made up in equal measure of locals and of foreigners, which were their Hanseatic companions. This could concern the compurgators and witnesses as much as the assembly of the jury and the courts themselves. The agreement of Russia in the Russian privileges was quite inventive, but stayed singular. Here, both the foreign and the local party are to name one witness each. If they chose the same witness, he had to be believed in. But if they did not agree on the same individual person, a lot was thrown. Whoever had the luck of the draw had the right to present his witness and to confirm his position by oath. According to in King Egbert's Carta Mercatorum, investigate commissions were made up of Englishmen and countrymen of the merchant, if in the same measure, in cases of conflict between a foreign merchant and an Englishman. If she had not enough compatriots available, the foreign party was allowed to fill up the open spots with locals whom she seemed suitable. I'll skip the next part for procedure, duration of proceedings, where I mainly argue how there is a constant strife of very short delays until you get a date in the court, and also for the court deliberations. I rather come to my conclusion. Theoretically, there are two possibly favorable ideal types of jurisdiction for merchant issues, either ordinary courts in favor of the tradesmen or a special jurisdiction for merchants, fair and markets with its own procedural regulations. The latter model is that of England. The former model is represented by Flanders, which took care of the merchants' issues by use of the ordinary jury courts. Here, as well as in England, the courts had the confidence of the merchants. The privileges do not reveal a preference of the merchants for either system. The Hanseatic representatives could identify and enforce their interests in both systems. There was a perpetual, precise catalogue of wishes which was given to the diplomatic delegations by the hometowns and the Hanseatic League. As long as the Hanseatic League had a powerful position, it could enforce most of its demands in all systems. That included fast proceedings, making up the deciding panels in equal measures, and the other points I've mentioned. Unlike the colonial powers in the 18th and 19th century, the Hanse merchants accepted the local courts they encountered abroad, but they pushed their hosts successfully into forming the procedure of these courts in a way that was acceptable to them. As there was much money involved, I took the liberty to label this strategy medieval forum shopping. This strategy mitigated the problem of overlapping jurisdictions to a certain degree. The question stayed complicated enough as the compromises led to different results from country to country. But as said in the beginning, this was a fact medieval merchants were just as used to as to the local variations in regard to measurements and currencies. The danger of overlapping jurisdiction was avoided by shaping the existing commercial courts to the needs of the customers. Before ending, I would like to change the point of view and add the perspective of non-merchants. They must have viewed the swift, unusual procedure of market and commercial courts with great suspicion. Those were the courts a normal person preferred not to get involved with. Here we see a person who rightfully shows a cold shoulder to the market judge. The market is represented by the cross. That's a market cross. The text of the Saxon Mirror confirms that the normal man may indeed does not have to answer to the market court unless he voluntarily takes part in the market business. The described compromises between the rulers and the foreign merchants generated a specific commercial law in which the rest of the population did not want to have any part. Thank you.
Thank you, Professor Albrecht.